going to talk about the concept of copyright infringement, with a specific focus on the copyright owner's exclusive right to make or authorize reproductions of their work. Since copyright's highly statutory, we're going to jump right into the statute now. We'll start with 17 U.S.C. section 501, which provides the cause of action for someone to sue for copyright infringement. Take a moment and read this statute. As you read this statute, you probably noticed that section 501 states that a copyright infringer is someone who violates any of the exclusive rights of the copyright owner that are provided in sections 106 through 122. In this series, we're going to primarily focus on section 106, which provides the main exclusive rights of a copyright owner. Sections 107 through 122 actually mostly involve limitations on the exclusive rights provided by section 106, and we'll take a closer look at one of those limitations, the fair use doctrine, next week. To understand the exclusive rights of the copyright owner, then, we need to turn to section 106. You'll see that there are 6 exclusive rights here. We'll talk about the statutory language in more depth, but for now I've distilled the rights to a few key points. The exclusive right to reproduce the work, the exclusive right to prepare derivative works, the exclusive right to distribute copies, the exclusive right to perform the work publicly, and the exclusive right to display the work publicly. Today, I'm just going to focus on the first right, the exclusive right to reproduce the work. This will also help frame all the other rights. First, let's take a look at the text of the right. Section 106 states that the copyright owner has the exclusive right to reproduce the copyrighted work in copies or phonorecords. Imagine that we're in 1996, and someone, let's call him the Richmeister, has gotten a hold of J.K. Rowling's unpublished manuscript for Harry Potter and the Philosopher's Stone. The Richmeister uses a copying machine to make many copies of the book. In this example, the Richmeister has violated J.K. Rowling's exclusive right to reproduce the copyrighted work in copies. Most claims of copyright infringement aren't that easy, however, as you'll see when you read Nichols versus Universal. Before you do that, however, you need to know about the basic legal framework for analyzing whether a right of reproduction has been violated. There are 2 elements for determining whether the exclusive right to reproduce the work has been violated. First, there must be copying. In my earlier example, the Richmeister clearly copied. We saw him use the photocopier, making copies. If there's no copying, however, there's no copyright infringement. In other words, if a work is independently created, it's not a copy of the original. In short, for there to be copyright infringement, there must be copying. Second, there must be what's called improper appropriation. That is, the thing that was copied was something that's protectable by copyright. Again, in my example, the Richmeister copied the entire book, something that's definitely protected by copyright, and to which he didn't have any rights. Got it? Good. Let's add another level of complexity. The first issue is, how do you prove that copying actually occurred? Sometimes you can catch the accused infringer red-handed, but usually there's no direct evidence of copying. So what else could you do to prove copying? Imagine that even though you didn't catch the Richmeister using the copier, you still have his copies. They're identical to Rowling's manuscript. The logical conclusion is that the Richmeister must have copied from Rowling. The possibility that he independently came up with that exact text is less likely than my cat refusing dinner. We call this striking similarity, and the idea is that when there's a very high degree of identity between 2 works, that can be enough to prove copying. But what if there are differences between the works? Perhaps the book the Richmeister is distributing has similarities to Rowling's work, such as heroes named Barry Cotter and Persephone Stranger, who go to an American school for witches and wizards. In this situation, it's possible to prove copying by a combination of access plus what we call probative similarity. The problem with this hypothetical, though, is that Rowling would have to demonstrate that the Richmeister had access, something that might be hard with an unpublished manuscript. On the other hand, once Rowling's book was published and became a worldwide sensation, proving access would be much easier. Another issue relates to the amount of similarity that's necessary to prove copying based on this theory, especially when elements may not be copied from the person asserting copyright, but from some earlier pre-existing source. You can find these elements in pretty much every set of jury instructions relating to copyright infringement. Jury instructions are instructions that the judge gives to a jury before the jury begins deliberation. They're often a key part of a jury trial that lawyers will make arguments about, but in many federal cases there are model jury instructions adopted by the circuit or written by an organization such as the American Bar Association. Here's an example of the model jury instruction from the Seventh Circuit for copyright infringement. You might imagine a judge reading this to a jury. To succeed on his claim, plaintiff must prove the following things: that the work is the subject of a valid copyright, that plaintiff owns the copyright, and defendant copied protected expression in plaintiff's copyrighted work. Assuming that the first two elements are met, the question presented by this jury instruction is whether the material that was copied was expression that's protectable by copyright. Consider, for example, the case of Feist versus Rural. In that case, Feist copied from Rural's telephone directories, so the element of copying was met. The problem was that the material that Feist copied wasn't something that was protectable by copyright. It consisted of facts. As a result, even though Feist copied from Rural, it wasn't infringing Rural's copyright. The issue of whether protected expression was copied is at the core of most copyright infringement cases that don't involve the complete reproduction of an entire work. Often only a portion or an element of a work is taken. Returning to the Harry Potter example, imagine that rather than copying the entirety of Rowling's novel, the Richmeister instead copies only Harry Potter and writes his own book with that character. He even goes so far as to transport Harry Potter into a parallel universe of his own creation. The Richmeister may have copied, but does the copying of just Harry Potter alone involve the copying of protected expression? Or to take another example, imagine that a musical artist writes a song that contains the same chord progression and rhythmic sequence as an earlier song, one that was quite popular and played on many radio stations. Is the copying of that chord progression and rhythmic sequence improper appropriation? That is, the copying of protected expression? This is the kind of question that's at the heart of your next reading, Nichols versus Universal. As you read this case, recognize that the judge, learned hand in this case, assumes copying. The consequence is that the opinion is entirely about the second element, whether protected expression was copied. With that, I'll leave you to the opinion. Stay safe, and I'll see you in class. And cut. Hey guys, is the Richmeister done making my copies yet?